In general, new scientific or technological developments can hold great hope for humanity, but their use as a means or method of warfare can pose risks to civilians and can challenge the application of international humanitarian law. Drones are not specifically mentioned in any international humanitarian law treaty, but that doesn't mean that their use occurs in legal vacuum. In fact, in many respects, the launching of a weapon from a drone raises very similar issues to the launching of a weapon from any other type of aircraft, whether it's a helicopter or a combat aircraft. The legality of the situation will very much depend on the circumstances. Because drones are remote controlled and they can travel outside of our traditional idea of the battlefield, then the context in which they're being used becomes very important, and whether that context can be characterized as an armed conflict or not can be very challenging and can lead to disputes. And it's the characterization of the conflict that will really determine whether international humanitarian law is applicable or not. Another complexity associated with the use of drones is the question of who may be targeted by the drone. Now, under IHL, a combatant or a fighter may be targeted. But what happens to a person who is conducting an attack from the territory of a state that is not a party to the conflict? Or what happens when a person conducts an attack and then moves into the territory of such a non-belligerent state? In the ICRC's view, in those situations, international humanitarian law is not applicable, and therefore the person wouldn't be a lawful target under the rules of armed conflict. ICRC has been examining the legal, ethical, military and technical aspects of autonomous weapons for some time. Our working definition of an autonomous weapon system is one which has autonomy in any of its critical functions. That is, it's a system that can select and attack targets autonomously. In using this description, our aim isn't to identify or define systems that are of concern. Rather, we've adopted this broad working definition in order to encourage a consideration of systems that are actually in use today, such as sentry system or missile or rocket defense systems, as well as new or emerging systems. There are clearly a number of military drivers for increased autonomy in weapon systems. Increased or improved mobility, the ability to operate in situations where communications would otherwise be very difficult, enhanced reaction times and decision-making times, as well as the ability to use fewer operators over a greater number of systems. Autonomous weapon systems are not mentioned in any international humanitarian law treaties, but IHL rules continue to be both relevant and applicable to these systems, not least the obligation under Article 36 of the First Additional Protocol to conduct reviews of the legality of any new weapon or method of warfare. IHL rules on the conduct of hostilities are addressed to the combatant or the fighter, the human, basically the people who plan, decide upon and execute attacks. These obligations cannot be delegated or given to a machine, a computer program or a weapon system. It is individuals at the end of the day who are responsible for complying with international humanitarian law. The question that the ICRC thinks now has to be answered is what is the minimum level of human control of autonomous weapon systems that's required for compliance with international humanitarian law, as well as with the principles of humanity and the dictates of public conscience. The most important element of human control is, I think, the ability of the operator to have sufficient information on and understanding of the weapon system itself and the operating environment and the interaction between those two things. After all, it is the human control that connects the decision maker, be it the combatant or the commander, who is responsible for complying with international humanitarian law, and the outcome of the use of that weapon system. It's important to note that both states and individuals can be held accountable for violations of international law. When it comes to individual responsibility under international humanitarian law or international criminal law, then the limits of human control or the unpredictability of the autonomous weapon system can make it difficult to identify who in the development, programming or activation stage could be held liable for a use that results in violation of international humanitarian law. Individuals involved in the use of an autonomous weapon system, whether at the programming or activation stage, may not have the requisite knowledge or intent required for liability under international law. Having said that, a programmer who programs an autonomous weapons system to commit war crimes would most certainly be criminally liable, as would a commander who decides to use an autonomous weapons system in an unlawful manner, for example, by using a system that is unable to distinguish between civilians and combatants in a densely populated area. Overall, as long as there's a human involved in the decision to deploy an autonomous weapon system, there's unlikely to be an accountability gap.